Good morning, everyone. Chris Gantt-Sorenson. I have to apologize to you. I had some technical snafus this morning, and I'm the reason we're getting started late, but we're excited and we'll make up for time. I have with me today McLean. I'm so excited he joined us. Anytime I have a client who has an employee welfare plan issue, particularly one that involves employee contributions into 401k plans or deferred compensation plans, any sort of untimely claim allegations or any sort of issue with plans, I always get Mac involved, and he always helps our clients beautifully. And so I'm excited to be able to talk with you with him present today. I am just a facilitator for the good advice he's going to share. And welcome Pickens County SHRM for joining us today as part of their lunchtime meeting. We're excited to partner with them for this. So with that being the case, let's go ahead and get rolling. All right, so this is the normal stuff we show you every time. Please do sign up for our blog. Most likely you did sign up for it because that's how you came to this meeting. But if you're a Pickens County SHRM member and you did not receive information about our blog, here's your opportunity to sign up for it. We offer all kinds of complimentary resources, and we post blogs with updates on the law as you need them. And so people are finding it very helpful. We also have our HSB COVID-19 page, which you should access as well. And there's a bunch of resources even outside of the employment law arena and all other areas of the law that you might find helpful. All right, so the things we're going to cover today, we're just going to talk to you a little bit about the liability for a fiduciary under the applicable healthcare plan laws. We're going to talk to you about the types of programs that are available to employers when they realize there's an error with their plan. If you ask for forgiveness, things always go better with IRS and DOL. And by forgiveness, I mean, we have an error, we corrected it, we let you know. Those are actions that both of those entities encourage. And it's been our experience, both Max and mine more with the DOL, his with IRS and DOL, that they mean what they say. And if you fix it and let them know that you've corrected it, they're not usually going to come sniffing around again. You know, they're going to take you at your word and be glad you fixed it. They might look and make sure you did. They're going to be glad you fixed it. We're going to talk to you a little bit about EBSA investigations. Mac is going to discuss some common 401k plan mistakes to kind of give you some ideas of stuff you might go back and make sure you're in good shape with. And then we'll hit some best practices at the end. You will have the slides, and so there's a lot of information on the slides that we put there for you that we won't necessarily cover in detail today, but that you can access later. All right, so liability for breach of fiduciary duty. 29 USC section 1109 is a federal statute. It is law. It outlines what liability a fiduciary of a plan could have. So if you look at this, not only is there liability for the fiduciary, where the fiduciary is covered by the plan or the entity, that sort of insurance, but you can also be held as a fiduciary for personal liability. Now, you may think fiduciary means touch the money or in charge of things, but fiduciary can be someone who's responsible for timely getting plan documents to an employee when they ask for it. And if you don't have that information in your department or in your hands, and you have to ask your broker for plan documents, plan descriptions, and it's over 30 days that it takes for you to get the forms to them, then you can get fined like $100 and something a day. I think it's up to $110. And so that's important to understand that plan fiduciary is pretty broadly defined. Mac's going to talk to you on the next slide about examples of folks who are plan fiduciaries.
So if you're asking the question, am I a plan fiduciary? You probably are, because the definition's so broad. As Chris indicated, anybody who touches the money is probably a plan fiduciary, but it's also people who touch the operations of the plan. The committee that makes discretionary decisions, the plan sponsor, the trustee of the plan, if there's a trust holding funds. Your plan probably names certain fiduciaries. It might name an investment advisor. All the plan administrators, all those people are fiduciaries. And the big message to take is that if you're a fiduciary, you have to, when you're making decisions, you have to think plan first, everyone else second. You have to be thinking in terms of the plan and the plan beneficiaries and what's best for them when you're making your decisions. And when I say that, following the plan as written, and doing things that are first best for the plan and not first best for you personally or the employer you work for. So being a fiduciary is an important concept. Yeah, I like to say, think about what you would do if you're holding somebody else's money. And how would the law look at you? That's how the law looks at you in this case. So identifying who the fiduciaries are and knowing that there's real responsibility is important. All right, and if you'll go to the next slide, what we're going to do now is talk about some of the programs that exist when you find a mistake and you want to try and fix it. Somebody told me this years ago. I hate even using the term, but somebody told me one time that managing an ERISA plan is like managed non-compliance. That there's so much you have to do and so much you have to be responsible for. It's hard to get it all right all the time. And so over the life of your retirement plan, there's probably going to be situations where something requires a fix, something requires a correction. And these on the screen right here are 3 programs the IRS has for fixing the problems that kind of fall under the IRS's jurisdiction. Now, one of the interesting things about retirement plans and welfare plans is they are both subject to the Internal Revenue Code because of the unique tax nature, say, of a 401k plan, where an employer puts money in and deducts it now, it grows tax-free, and it's not income until somebody withdraws it. Because of those special tax features, the Internal Revenue Code has an incredible set of rules on how a qualified retirement plan has to operate. Similarly, a law called ERISA in the 1970s was passed by Congress, and it is a law that protects the rights of participants with respect to retirement plans and welfare plans. So you've got these 2 bodies of law that you have to comply with. And what they have done is said some problems, if you're fixing them, you deal with the IRS. And some problems, if you're fixing them, you deal with the United States Department of Labor. So what we've got listed here are some of the programs the IRS has when you're fixing a problem allocated to the IRS. So their fixed program is called Employee Plans Compliance Resolution System. And they've got 3 methods to fix, big picture methods for fixing problems. There is self-correction program. That's the good one. That's nice and easy. It's if an operational mistake happens and it's insignificant, or if an operational mistake happens and it's significant but caught within a relatively short period of time, then you can use self-correction. And self-correction means you probably have to call a lawyer or other advisor or your plan vendor, and they'll tell you what the proper fix is, and then you just correct it. And the good news, you don't have to call the IRS, you don't have to send anything to the IRS, you just fix it. And the method and the IRS has issued methodologies on how most of these fixes have to happen. And the overriding theme is that the fix has to put everybody back in the place they would have been had it been done right the first time. And that sounds like a simple methodology, but sometimes that can be tricky. And we'll talk more about that later. So anyway, if you fall within number one, it's just operational and either insignificant or significant caught quickly, you can just fix it using the protocols established by the IRS and move on. The second one, voluntary correction program, VCP. That is a program when you can't self-correct, but is available prior to you having gotten a letter from the IRS that there's a problem. And if you fall under VCP, it's the same concept. You figure out the right fix, you do the fix, but then you submit a VCP paperwork and a much lower fee than the fines you could possibly have. And the fees are based on the size of your plan too. So larger plans pay larger fees, but none of the fees under VCP are particularly onerous. And you submit that here was the problem, here's the fix. The IRS even has some forms you can use as a template for sending it in, and you pay the fee, submit it, pay.gov, and you get at some point you eventually get a form letter back that says we accepted it, and that's it. And you keep that letter, and it's evidence that you had a problem but fixed it, and the IRS can't give you grief about it in the future. The third program on this slide is called Audit CAP, Audit Closing Agreement Program. And this is your only fix when you've gotten the letter from the IRS that there's a mistake. And you basically lose the ability to claim the very low VCP fees, but you do still have a program you can go in and pay reduced fines and fees because you're telling them even though you've gotten a letter, you fixed it, and you work out a much lesser fee than it would be. All three of those programs result in either zero or much less fees. The trick is, though, sometimes the fix costs money, as we'll tell you more later. So that's, I think Chris is doing the next slide. Hey, you're muted.
Thank you, Mac. Thank you. The DOL correction programs sound a lot like the IRS programs, but they are different. Important thing to note that if you are going to participate in the correction programs, you will not be able to do so if an investigation has already been instituted. What DOL envisions, the Department of Labor envisions, is that when you yourself determine there has been a violation, you fix it, and then you fill out the correction forms. You participate in one of the two programs we're going to highlight, and notify them and tell them what you did to fix it. So that's how quickly it's expected to happen. Something to keep in mind too, in regards to the voluntary fiduciary compliance program, which we'll talk in more detail about that, but that is specifically the one where you have not made timely contributions to a plan, is that you correct the violations, you complete the application, and that you do so, you identify the issue and correct the issue within a certain amount of time. There are 19 transactions covered in the voluntary fiduciary correction program, and we've listed them on the slides. We're not going to go through all of them, but want you to know what they are so that when you realize that one of these applies to your plans, you can act quickly. Next slide. Some of the transaction covered. These are these two slides. Next slide are all of the VFCP transactions.
Chris,
go ahead.
I'll mention one thing too. The way they've allocated it is things that are more like mishandling of money or doing a transaction with a conflict of interest type party, those tend to fall under these Department of Labor corrections. The transactions that tend to fall under the IRS corrections are the ones like, I didn't run the plan right. The plan said contribute X and I didn't contribute the right amount.
Yeah, thank you for that good point. All right, pop on to the next slide. I was thinking that we were talking, I'm getting ahead of myself. I was hoping to talk to you about the safe harbor. So I just talked to you about the VFCP. There's another one, which is the DFVCP.
Yeah. So I'll talk about that. So this program, so interestingly, you probably know that ERISA plans have to file a Form 5500, and it's going to say it's an IRS form, but between the IRS and the Department of Labor, they've allocated Form 5500 problems to the Department of Labor, okay? And so here is the program, this DFVCP is the Department of Labor's program when the annual Form 5500 is either not filed or filed late or something like that. And the interesting thing here about 5500, if you don't know, is that it's a public record. So, you know, anybody can see it. You can go on the internet. If you know where to look, you can find old 5500s. And a qualified retirement plan, like a 401k plan, always files a 5500, okay, every year. And then if it exceeds a certain size, and I believe it's 100 participants, not only do you file a 5500, but it has to be audited, and there has to be an audit report attached to the 5500. Welfare plans like health plans or severance plans or other ERISA welfare benefit plans, they may have to file a 5500. They have to file it if there's a trust involved or if there are more than 100 participants. And there may be other nuances to it, but what I see a lot of is it isn't so much nobody knew to file, but a lot of times when you change from the under 100 to over 100 and the filing is different, people don't catch it sometimes. And so you might have a small welfare plan and then it exceeds 100 people and all of a sudden you're supposed to file 5500 and you don't catch it, or you're doing a 5500 and exceeds 100 and you didn't know to get an audit and now you've got an incomplete 5500. The other funny thing too about these two is for a qualified retirement plan like a 401k plan, anybody who had the right to make an elective deferral is counted as a participant, okay? That's not the way a welfare plan does it. So the inconsistency there makes it easy to miss. I've seen many retirement plans where you know, you send in data, but you don't send in all the zeros, or you don't tell somebody had the right to make a contribution and they didn't, and nobody catches that you exceeded 100 people and needed an audit. And going backwards on audits can be a problem. So the beauty of this program is, for whatever reason, if you didn't do the 5500 right, you're late or you failed to file or whatever, you can fix it by submitting this. You pay a much smaller fee for the late filing, and you submit it, you pay the fee, and you're done. If you don't use this program, then you see at the bottom of this slide, the penalties can be extreme for failing to file a 5500. Let's go to the next slide.
We've got a question. I'll go ahead and answer it. It's a good one. If I fix, the question is, if someone fixes the error, the contribution error into the contribution into the plan, if they fix it quickly, do they have to report it? You do have a safe harbor. And specifically, it's 7 days usually, or as soon as feasibly possible. And the Department of Labor will look at how quickly you've been able to do it in the past. And that's what they'll probably judge as far as what's reasonable, but no more than 7 days. And I think there's also a different standard if you're a bigger employer. And so that is something, go ahead, Matt.
Yeah, and if you've generally sent all your money on time, you just forgot, you know, Eddie's match didn't get made or something, you know, you can, that would be an operational and insignificant error that you could fix using the suggested fix protocols without doing a VCP. You could do it under the self-correction thing under the IRS. So I think the answer is yes.
That's right. That's right. And it's for 7 days. It's going to be set for an entity that has under 100 employees. Those that have over 100 are no more than 7 days, and they really do look at more average of what you normally did it. So obviously the answer to it is get it in as soon as possible. And if you're realizing that you've made the error, you're going to want to get it in as soon as possible anyway, whatever that looks like, and then look at kind of how late it is to determine whether or not you need to do the VFCP. But you're absolutely right that just because you're late doesn't mean you always need to do the VFCP. I would say that, yeah.
That's right. And if it's a lengthy period of time, you probably have to calculate, you have to give a little bit extra for lost earnings. And that goes to the IRS protocols and Department of Labor protocols for fixing things. But if you're late on something by a certain amount, you need to add a kicker for lost earnings or interest.
That's right. And we've got some good resources for that too.
Sure.
Slide. So the EBSA investigations. So when you get one of these notices, then it's too late to correct. And this is when you call MAC, frankly. And these are the most common times, the most common things that are going to trigger an EBSA investigation. And y'all, I'm sure y'all know who EBSA is, but just for purposes of being clear, it's the Employee Benefit Security Act. It's administration. Employee Benefit Security Administration. It's a division of the Department of Labor. And so if they are contacting you, and that's going to probably mean that you're being investigated. It's not the end of the world, and they actually work with employers. They're compliance oriented. They just want to fix things. But these are the types of things that they'll be usually contacting you about. You've got a participant who's made a complaint, and that happens, you know, obviously when they look into their plan and they see that their money isn't there or some other issue. Form 5500 answers, you know, if they don't look right. Service provider referrals, that'll happen if your service provider who's in charge of helping you administer the plan determines that there's a violation. They will include that on reports that they're required to alert and send to the EBSA and the DOL. If there is a priority initiative or enforcement project, you know, something that's important to the EBSA or the DOL for benefit plans, they may spot pick you to determine whether or not you're compliant with whatever the priority is at the time. Improper administration practices and ESOPs. And so I didn't know, Mac, if you'd want to weigh in a little bit on what they might do.
Let me talk about ESOPs for a second. I read an article recently where it talked about, and of course, EBSA, the investigation arm of the Department of Labor, that was talking about how the EBSA looked at ESOPs. And an ESOP is a qualified retirement plan that under statute has the ability to do some things other retirement plans can't typically do. Like it can hold a bunch of employer stock. It can, it has some relief from the conflict of interest rules. But as a result, the EBSA kind of watches them very carefully. And I read an article recently, and of course, if I read an article on the internet, you know it's true. But the article I read said that 5% of all EBSA investigations were on, in the last 10 years, were on ESOPs, and that there were 2,069 investigations on ESOPs in a 10-year period. 60% of those found actual violations. And the typical things that they would find with ESOPs are they didn't handle, their ESOPs can borrow money to make plan contributions. They didn't follow the loan terms right, or they didn't do the annual valuation of employer stock properly. So what I'm trying to get at is that ESOPs, they look at those real carefully. The other thing too, I have read and believe to be true is that, you know, the IRS sometimes does audits that are random, okay? But my understanding is that the EBSA doesn't really do random audits. If they knock on your door, there's usually a reason or something that raised, that caused them to do so. That's all I've got for this slide. So,
Right. So Mac, I'm hoping you're going to run through some of these common mistakes and give them some input on those.
Yeah, glad to. So Chris and I sat down and tried to figure out the things we saw the most, and we slapped them on here and the next slide. Stay here for now, but these are some of the most common ones. And the interesting thing for me, again, some of these fall under IRS, some of them DOL, but most of the fix protocols are put out in rulings by the IRS, and there's Revenue Procedure 2019-19 is the most recent comprehensive list of here's how common plan problems should be fixed. And it states some of those fixes. What I'll do is I'll walk through this list a little bit and talk about some of the fixes. So a contribution that's late, I will say that's typically the situation Chris was talking about, where we've got employees making elective deferrals to a 401k plan. Of course, that goes through the employer's payroll system. The Department of Labor views that money to be planned money the minute it's withheld from the employee. So there's a time frame that employers should process it and get it into the plan. And if you miss this, it's as soon as possible, but not later than 7 days, as Chris said. But people don't realize sometimes that that's the standard. They think, oh, well, if I'm slow to, it helps my company cash flow if I take my time sending this to the plan. Then the Department of Labor views it as if you impermissibly borrowed plan dollars, and that violates a flood of rules. And so that's a common mistake. And the fix is to get the money into the plan as soon as possible, and then to see if you or if you would benefit from one of the Department of Labor late contribution programs. And usually the fix includes getting into the Department of Labor's calculator and figuring out what kind of a kicker you need to add because it was late getting into the plan and there's some earnings lost. So that's the common fix for that sort of late contribution. The next one, failure to match. You know, if you didn't match, then you need to match. And the fix is to do what you said you're going to do, and to add a kicker for the delay that tries to make the employee whole for the kind of earnings they would have gotten had the match gotten in there timely. And there are a couple of alternative ways to calculate lost earnings, but that's the concept. Excess plan contributions. There's a million ways, well, not a million, but a lot of ways you can put too much money into the plan, either too much for a person, too much as an employer. there are a lot of dollar limits that apply, but all of them follow this concept. If it's employer money and too much went into a single person's account, it's got to come out of that person's account, including earnings allocated to it while it was there. And typically, if it's employer dollars, it goes into a suspense account and used however your plan document says you handle suspense accounts. Usually you can use it for future contributions. If it's employee dollars, it usually gets kicked back to the employee. So that's the fix there. Failure to timely file the 5500, that's your 4-letter acronym under the Department of Labor, where you submit it late and explain and pay a small fee. If you do not satisfy the ADP and ACP tests, those are your tests that compare the deferrals of a highly compensated employee with the deferrals of a non-highly, and or the employer contribution matches for the other. And they have to come within a certain distance of each other or you don't pass the test. And when you don't satisfy, you've got 2 ways to fix it. Either you kick some money back to the employee, the highly compensated who put too much in, or the employer puts more in for the non-highly compensated. So the fix on those cases would look like that. This next one, an eligible employee is not given an opportunity to make a deferral. That's one I see way more often than we ought to see. And that has a surprising fix. So you might have a plan that doesn't really even involve employers putting in money. You just let employees defer their own money to a 401k plan. Well, if there's somebody who was supposed to get in on January 1 and supposed to have the opportunity to make a deferral on January 1, but you don't get them in until March, then the IRS's position on the fix is that they lost something. And what the fix is that the IRS believes is appropriate is that you figure out approximately what they would have put in or what people as a whole are generally putting in. And then you cut that in half and the employer pays that. Basically, they split the difference because it was an employee only thing and you can't make up for it. But it's due to the blame of the employer. So the employer ends up having to come out of pocket for the lost opportunity for the employee to get a tax benefit from a deferral. That's the fix. And plus a kicker for lost earnings. So that one I've seen really shock some plan sponsors when they thought they had a plan that they never had to make employer contributions. Another common mistake is that you've got some latitude in your plan, like a 401k plan or a profit sharing plan, to define your compensation. So, for example, you might exclude the year-end bonus. You might include the year-end bonus. You might include the salary that somebody wasn't taxed on because they put it in a cafeteria plan. You might exclude that. And the point is that the number on box 1 of your W-2 might not be the same as the plan compensation number. And so bad information might get sent to the vendor or somebody doesn't match it up. And all of a sudden you didn't put the right amount in for somebody, or somebody didn't get to defer on their year-end bonus, or somebody erroneously deferred on the year-end bonus. So it's really important that you get these right, and it could trigger either a kickback or one of the fixes I described earlier, where somebody didn't get the right to defer, the employer might have to pay something. The next one is participant loans. You know, they've got plan requirements and law requirements on how to handle participant loans. And this one's a really nasty one because it implicates both the IRS and the Department of Labor. And both sides have sort of taken the position that there are situations where they might have to weigh in on fixing a plan loan. And if there are rules that say you have to default on a plan loan if they miss after a certain period of time, and then a default could result in tax consequence to an employee. So that's a particularly hairy one to address and fix. Again, if it's just we did the math wrong and they need to catch up on payments, you can catch them up, and that's fine as long as, or you can amortize the loan as long as it's not longer than the 5-year length period of the loan. Those are easy fixes. The harder fixes is if the mistake caused a loan to drag out for more than 5 years, you've broken a big rule, and it's more challenging to fix. Last on this slide is improper hardship distributions. You know, I don't see as many hardship distributions as I used to see, but an improper one would either be a distribution made from a plan that didn't have the language authorizing it, or something like that. And the fix would either be to amend your plan to authorize hardship distributions, or if you don't do that and you made a distribution that either was too large or not authorized, then you've got to figure out a way to get the employee to put the money back. That's the fix, and that's a hard one. So if you go to the next slide, we'll do these last several. Top-heavy plans. So most employers, you know, have a few highly competent people at the top, and as you get more and more employees, you know, the salaries are less, you have a large rank and file. But there are some employers that don't follow that model, like professionals, you know, CPAs, physicians. They may have a lot of people who are paid a lot, and then their administrative staff is small. Those plans can easily get top heavy because there's so many highly compensated people who have large plan account balances. And if you're top heavy, then certain minimum employer contributions have to be made for the non-highly compensated. And the key is if you know you're top heavy, it's easy to plan for. But every now and then, people don't realize they're top heavy, and they don't make those minimum contributions, or they don't realize, this is a really interesting one. If an employee comes into the plan, say October 1, and is only in the plan 3 months, the top heavy minimum for them is not based on their 3 months participation in the plan. It's on their year's salary. So that surprises people too. So top heavy plans, or plans that potentially can be top heavy, ought to be alerted to those issues and be ahead of them. Failing to follow the terms of your plan, those are operational defects, and those are usually fall under SCP or VCP. But that's just a catch-all for, I didn't do what the plan said. And if the plan said put more money in, the fix is to put more money in. If the plan says you put too much money in, fix is kick some out or put it in a suspense account. So but the fixes tend to be common sense to try to put people back the way they should have been. The next one is failing to amend plans to reflect changes in laws. So you've got a duty to amend your plan periodically. And sometimes when you hear about the government passing rules that say, oh, for the COVID, you can take distributions if you do a plan amendment. You have to do the plan amendment in order to do that. So typically, if you fail to timely amend a plan, that falls under VCP. You can't self-correct that. And that's the process for fixing it. You say, oh, we operated it right, but didn't get it amended on time. So we go under VCP and pay a fee. And I think these last two are kind of catch-alls that just say if you don't follow the rules, you got to use the IRS or DOL fixed protocols. Okay, why don't you talk for a second, Chris?
You got it. Well, you're not going to love this. Take a sip of water, because I wanted you to tell them a little bit about automatic enrollment. You know, that happened in one of the cases that you got me, or that I got you involved in for a client. And I think that was, to me, that maybe it shouldn't be a sleeper issue, but if you could mention it.
Well, it is. No, that's a great one. So yeah. Auto enroll is really pushed by plan vendors because it's very effective at getting people into the plan, and people, once they're in the plan, like being there. And it also, the vendors charge more when there's more money in the plan, so they push it. And all the tests tend to pass easier when more people are in the plan. So auto enroll is a good thing as a general concept, and it's pushed hard by vendors. But if you don't do it right, you can easily trip up. So for example, if under auto enroll, you're supposed to enroll everybody January 1, you got to do it. And if somebody doesn't fill out a form or something, that's not a good, that's not necessarily a good excuse. So, and if it says they're auto enrolled as of January 1, and you're busy, you can't kick the can to February. You've got to auto enroll them and get them in and start withdrawing the elective deferrals or whatever you do under auto enroll. And then there's also a concept called auto escalate. And the same issue, you can't forget about it. You gotta do it. And then the question becomes, well, what if Eddie comes by the office? He didn't feel like filling out a form, but he just said, "Oh, I don't want to be auto enrolled. Don't put me down." And then somebody doesn't handle it right because everybody else is doing automated something. It's easy to get some factual confusion and problems. So if you have auto enroll or auto escalate, you need to be vigilant about following those terms.
All right. And then there's also a question. Wayne Music asks, what type of documentation do you have to keep if you do a VCP calculator and add the additional money into the employee's account?
Well, typically you submit those calculations with your VCP. I mean, they don't allow you to just go, we did the math and here it is. You got to show them the math and submit it with that. And so by doing that, it's the documentation doesn't get lost.
All right. So we talked a little bit about VFCCP or VFCP. Sorry, let's go ahead and slide to the next slide. No pun intended. And so we already talked about some of these things about the safe harbor rule. That is very important. They are strict on it. We've talked about that and we've explained it. So let's go ahead and get a little bit more into the program, the VFCP. And I've already got 2 links ready to send out that either Keely or Brittany will send out when they send the slides, so that you have a link to the VFCP and to the DFVCP. And there's some great helpful links there. I will tell you, this is a very easy database to navigate and figure out what you need to do. And then they have the applications on both, and then they have instructions for the applications. And so those are very user-friendly. Let's go ahead and slide to the, okay. So we keep saying this over and over again, can't stress it enough, fix the problem, fix it ASAP. Then start working on the VFCP application. When you do that, it's going to also help you think through the types of money you need to put in. Mac has talked about that, but you do have to do lost profits. So if I was supposed to be in January and the plan grew in a certain amount, then you're going to have to make sure I'm getting paid that. And there, as he indicated, are several different ways to do that. But it is important that whichever way that you determine what the lost earnings are is one you can back up, not just something that you've pulled out of the sky, or that you thought, well, this sounds good enough. You either need to be able to explain it very specifically, mathematically how you got there, or even better would be you have someone value it. Most of you have companies that are administering these 401k plans for you. They can perform this analysis for you and tell you what you need to put in. That's something you can rely on. That's probably part of what they are willing to do for you without an additional fee anyway. But make sure that however you're getting to your number, it's number one, you can explain. Number two is reasonable. And number three is recognized as the appropriate means for doing it. So that's important. And a lot of times when this has been going on a little bit too long and the numbers are high, you might have decision makers, pocketbook people, worried about how much it's going to cost trying to cut costs. Please do not do that, because the whole reason we're doing it to fix it and to avoid excise tax tasks and any sort of criminal liability and other things, we will start shooting ourselves in the foot. So that's not a place to cut corners. Do it right, pay what you need to pay in. Then you file your application. So notice here that we're saying VFCP or DVVCP. Oh, but you might also have to do a simultaneous IRS correction program. And that's absolutely true. These two are not mutually exclusive, and there may be times when you need to do both. So that's something that, in fact, I would recommend. That's when you're calling MAC and saying, do I need to do both? Ideally, we're hoping you're calling us even if you've got a VFCP issue. Next slide. So here are some of the things that you can face legal remedies for. Obviously, we've already talked about it. Legally, you've got to restore unpaid contributions and pay interest on it. Also, any loss valuation. Interest
and some really bad things can happen if you don't, fix the problem. That's what she's telling you here.
That's right. So, and interest is different, obviously, than earnings, but, apply a reasonable interest amount to what it needs to be to it. So then here we get into, as Mac pointed out, some of the really bad things. Equitable remedies, we might remove the fiduciaries. Civil penalties. These can be avoided if you correct the mistake, but if not, it's 20% of the unpaid contributions, up to 20%. Next slide. We get into the excise taxes. Again, if you've done VFCP, you corrected it, you can avoid the excise tax. You're looking to get a no action letter from the Department of Labor. That's when you realize, all right, I fixed it. Yeah. I submitted the application. It looks all right. You avoid the 15% excise tax on the amount involved in the transaction. And incidentally, on this excise tax, if it's not fixed within the tax year, then it's an excise tax of 100% of the amount involved. So that's
you have to fix.
Yeah, that's right. I believe we're driving it home well enough, don't you think, Mac? So criminal penalties, attorney's fees, lawsuits. We've got a couple of more questions. If we can go ahead and slide to the next slide, and let me check out somebody says my video is upside down. Thank you. Sorry to make you. Is this better? Mac, am I still upside down?
You look okay to me.
I'm sorry, y'all.
Yeah, it's fixed now.
We had to have me jump on my phone and do this. That's how the fix for it. So I apologize. I'm not as stationary as I might normally be. And I'm afraid that was the question that I was looking for. It's fixed now. I'm looking. I think that I've gotten all the questions. So
all right, let me talk about this slide for a second. And I alluded to this earlier that there are certain transactions that are prohibited for conflict of interest purposes. And these are on the list of prohibited transactions. And if you get involved in one of these, you have to use one of the DOL programs to fix it. But if you have a prohibited transaction, you got the excise tax and the 100% excise tax if you don't fix it. Examples of prohibited transactions are any, and there are some exceptions that are common sense, but the spirit of it is that any sale or exchange between the plan and a disqualified person is prohibited. And a disqualified person it's like the list of fiduciaries. It's very broad. It's anybody who is a fiduciary, anybody who's an employer, anybody who's a service provider, their family, corporate officers, owners. So, I mean, it's a broad list. So, for example, I know kind of in the early days of retirement plans, we used to see people be more cavalier about this. Like, for example, I remember when I first started practicing law, there was a small company's retirement plan, and they used plan assets to buy a beach house, and all the owners used it. And that's absolutely a prohibited transaction because it's like using personally plan assets. Same thing comes if you take the plan and you use the main owner's oldest child as the stockbroker for the plan. You know, all of a sudden you've got a potential prohibited transaction there because, you know, they're providing goods and services and they were selected because they're somebody's, you know, family relationship. So the idea is if you've got plan assets, you need to deal generally with third parties and make decisions based on the best interests of the plan. And yeah, that's the key thing. But every now and then you get involved in ones you don't realize and you end up having to unravel it. And that's what these programs are for. And they tend to pop up more when you buy untraditional assets in your plan. That's my personal take on it. That's where the door gets thrown wide open because there's so many opportunities to have a prohibited transaction when you've got an odd asset.
So, Mac, state, please, what sort of paperwork an employer or a plan needs to show if they have a later to fix something.
Say that again, please.
State what sort of documentation is needed if someone has complied with the VFCP, used the calculator to determine how much they needed to pay. What sort of documentation do they need to keep?
Well, you submit all that with the submission, and then when you get the letter back, either from the IRS or the no action letter from the DOL, you put that on the back of your what you submitted and just throw it in a folder, and you've got it. And that's really all you do. And in almost every case, you just get back a one-page okay type response from the IRS or Department of Labor if you corrected it using the recommended protocols.
I was gonna say that's the good news. That's the good news if you get that. All right. So if we the next slide and we'll hit some best practices. And I want to end with sort of a little alert. I know a sleeper issue. So obviously maintain accurate census information for plan participant population and do missing participant searches. You know, that's a way for you to identify folks that should have been offered an invitation to participate in the plan and are not in the plan. Another thing that's very, very important is building in communication steps during onboarding, enrollment, and in your plans and your handbooks and your communications with your employees. If you are an employer who has an electronic database, you want to make this very visible information about when they can jump in and be a part of the plan, because what you're doing is building in protections for yourself, for the employees to be aware of when they should be jumping in and reaching out to you and alerting you to it. It's a great checks and balance to make sure that you are.
Yeah, I'm sorry. I was going to say that I think the number one reason you get investigated by somebody is when an aggrieved employee writes a letter.
Yeah. And so if you're making all kinds of opportunities for them, you can't pass the liability for getting them enrolled or offered an enrollment to them, but you can give them all kinds of opportunities to help you keep up with it. And that only helps you. So everything you can do to educate your employees. Onboarding is always good. We all, when we get hired, remember, we get to enroll in 6 months, or whatever the thing is. We all remember when we get hired, you're vested in 3. So those types of things, communicating what benefits they have to them at the outset and alerting them, and then having things on board that remind them is going to help you keep up with it too. Document procedures and actions always, right? And so in the last minute, I want to give you guys a horror story. So one of my clients years ago had a situation that arose with an employee who was involved in the HR and was the only signatory on the 401k plan. And this was someone that, issues went south with them, and all of a sudden they weren't in, and the employer did not realize that this employee was the only signatory on the 401k plan until then, when they couldn't access it, when they couldn't get in and figure out what was going on, when they couldn't get in and make sure that, deposits were being made and that sort of thing. And so they were starting to worry about compliance. Never have only one person as a signatory on your plan. Never, 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 never. Always have an access for two folks. And that'd be minimum. And that you even make sure that someone's got access to the password information if something happens with the two folks. That's just number one best practice on that issue. But number two, breach of trust conviction in South Carolina. What that means is this person was convicted of possibly embezzling for former employer. Not always, but if you were embezzling from a former employer, the criminal charge is going to be breach of trust. And that's difficult because not all of us would look at breach of trust immediately, assume that that could have embezzlement connotations. But in this instance, that particular employee had worked at two different employers prior, and she had two breach of trust convictions spanning 5 years apart. And so now, here's this poor employer, can't access the 401k, has discovered that this person has a breach of trust issue, and you can imagine what was running through their minds. And so look out for breach of trust. If you're hiring somebody that's going to be touching money, you really need to look into the breach of trust conviction. That's something that the EEOC would support because that's job consistent with business necessity. And also, please make sure that you are keeping up with accurate passwords and accurate access and accurate contacts of all of your accounts so that you can jump in and keep your compliance practices going. If for some reason, the person who's in charge of oversighting that administrative practice has to disappear for any reason or has to step down quickly. So, Matt, is there anything else you would add? Your advice and your information was so great. There's so much we could have covered. But I know that what you said was helpful. Anything else?
No, you could talk forever on this stuff. And I almost brought in a copy of the Internal Revenue Code and regs and ERISA and regs on these things just to show you, it would be pages and pages. So there's a lot of ways you can get tripped up. And as long as your vendor's setting up processes to prevent you from getting messed up, but you've got to give them good information. That's why that census information is so important. If they don't have good information, they may not catch the problem.
That plus they have strong indemnification clauses in those provisions, and you're always liable for anything your vendor does wrong, and you're you're always liable for giving them the wrong information. It's always going to fall back on you. You can't push that fiduciary obligation to any vendor, so that's important to keep in mind. All right. Well, thank you. Thank you for all of you who have attended, Pickens County SHRM participants as well, all of the folks that come to our webinars and support us, and we hope you found it helpful. We're always open to ideas about what you might like to hear about. Mac, all of his contact information is on this last slide. Feel free to call him. He knows what he's doing. He's who I call when we have problems like this. I hope everybody has a great afternoon. Thank you, Mac.
Thanks.
Thanks for joining this webinar presented by Haynsworth Sinkler Boyd. To learn more about the firm and its services, visit hsblawfirm.com.